Yeah.
Okay,
I'll see
go
Bill,
ahead.
I'll see Joe Warner tomorrow.
Oh, nice guy. Very
Yeah.
nice. Helpful.
Yeah.
Okay, all right, Jessica.
Hey, Bill, are you unmuted? Bill Rosen?
Yes, I am.
Okay, here's Amy. We get, you're still muted. There you go, Amy.
Hello.
How are you?
Good. How are you?
Good. We don't have everybody yet. We're,
Oh,
We-
Tom's here.
Tom's here too?
Yep, he just
Okay.
came in.
All right, Tom's here, so we're just missing Rob.
See, what happens, Amy, is you were sitting in the waiting room, but I was on the pre-game type of thing. So it doesn't show up that you're sitting there and I was waiting to broadcast till you showed up. So
Oh,
that's why I
no.
didn't see it until I hit wait to broadcast. So I'm glad you texted me.
Okay. Yeah, you know, I didn't get a panelist link. Maybe I missed it.
I sent it again today.
I didn't use one to get
There you
into
go.
this either. I just used the regular meeting ID.
Yeah.
Tom, we see it, Tom, but you gotta unmute yourself. We can't hear you.
Now you can.
There you go. All right, good. All right. Do we know Jess, we don't know if Rob is coming?
He didn't say he wasn't, so
Okay. All right. Well, what do you think, Amy? Should we start? What do you feel?
I'm happy to start now.
Okay. All right. Well, I guess, are we handling this is, Amy, as though this is a regular meeting? So do I have to go through the whole, or can we just start?
No, we can just start.
Okay. I don't have to poll who's here or anything like that?
Nope, we can just
Good.
note attendance for the record. Nobody, I can see that nobody has called in. It's just board members. But
Okay.
for the record, Rick, you can state who's here, ask Jess to do it, or everyone else can take turn saying who it is.
All right. Well, I can do it real quick, just for the record. Okay. I am here, Richard Jerzak, and then John Bernardo is here. Thomas Daniels is here. William Mark is here. William Rosen is here. Okay. Wayne Pimentel is here. Jessica Spence is here. And Amy Goins is here. Okay. Did I catch everybody? I think so. All right. This is a work session of the Zoning Board of Review. We're going to go over a few things today. This, I hope, will satisfy the requirement of 906D of the ordinance, which requires that all zoning board members have 2 hours of instructions, okay, every year. And Amy, go to it. You're the instructor.
Sure.
Or is it a instructrix or instructor?
It's just.
Oh.
So this, I'm gonna say it's not gonna be 2 hours, so it will satisfy the spirit, but not the letter of that requirement.
enough.
So I'm gonna shoot for 20 minutes.
Good.
And Jess, for new members, have you included the templates that I developed in the new member packet? So does everyone have those, including Bill and, well, both Bills?
I know Bill Mark does, and I believe Bill Rosen should.
I do.
Okay. I'm gonna resend those, and we're waiting on another new member, correct? We're waiting for the council to appoint one? Okay.
Yeah, I don't know that we have anyone even hanging out waiting to be appointed. So
No takers?
yeah.
So, and do you have those handy, Jess? If not, I can share my screen.
I do not. They're in a hard folder in the office.
Okay, let me attempt to do mine.
Right, and I do have someone just join the meeting to watch, Terry Genties.
Okay.
You know, we all have, oh, you have it. All right, good.
Can you see this now?
Yes.
Okay, so this is a template, and
Quick question, Amy.
yes.
Would you be able to send that out as a doc, like a Word doc or something like along those lines?
Yeah, I think I have it as PDFs, but I'll ask just you. Do you want it this instant or after the meeting?
No. Just
Yeah, sure. Yep, will do. So I wrote these up a couple of years ago, and it's not rocket science. It's more or less the standards for dimensional variance, special use permit, and use variance, which we see less often. And the key word in this that I want to focus on and have you remember is because. So when you make a motion, it's very important. The magic words from the ordinance are only really 50%. That's only one half of it. The second and the critical half is saying because. So why is there a hardship? Because of the land, because it's an undersized lot, because it's encumbered by wetlands. Why is the structure, or, why is there a hardship? Because the existing structure is within the setback area. There's a very small building envelope. Something like that. So the because needs to really be articulated for each standard. So the hardship is not the result of any prior action of the applicant because the applicant purchased the property in its existing condition because the house has been here since 1950 and it's located within the front setback. Will or will not alter the general character of the surrounding area. We know that's the squishiest standard, but if they're looking to build up a one-story house in a neighborhood of two-story houses, it's consistent with the surrounding area. Are most of the homes in the area within the front setback, and this person wants 2 feet of setback relief for a small addition consistent with the surrounding area. Least relief necessary. So you get my drift. The big thing we need to do is remember that when the board discusses each application, usually you have a robust discussion and the person making the motion should try to attempt to capture that discussion to the best of their ability in the motion itself. Because this is all geared to making sure that when our decisions are appealed to the Superior Court, they are, number one, accepted initially as reviewable by a judge versus being kicked back and the judge says the decision isn't good enough, you need to articulate the decision better. And then of course we want them to be upheld on the merits. So we always submit the stenographic record, the transcript of the meeting to the court, but the judge simply does not want to take the time to read the transcript. If the judge cannot look at the motion itself, the decision itself, and understand why the board decided as it did on each and every element, then the judge will remand the matter back to the zoning board. And that can create problems when there's sometimes a delay between when the hearing took place and when the judicial decision is rendered. This recent one with Garrett Homes, the attorney on appeal took what I think was probably a smart tactic and tried to have the decision remanded initially before it was briefed. And because I preferred not to set the precedent of having the judge tell us the decision wasn't sufficient, I said, well, let's agree that we can have it remanded by consent to the board. So it's been a while since the Superior Court has remanded one of this zoning board's decisions for insufficient findings of fact. And in fact, the last time it happened a couple of years ago stemmed from a hearing that I want to say was held in 2009 or 2010. And so when that decision came down, we reviewed it internally and said, we're going to have a whole new hearing because the membership of the board had totally changed. And as you know, each, from meeting to meeting, the membership of the zoning board needs to be the same when they're voting on a specific application. So if membership changes between the time a hearing occurs and the time a decision is remanded, then we've got to do the whole thing again. And that creates major problems. So the big points that I want to make is don't forget the word because. And by the way, I just want to say the board routinely does an excellent job at motions. This is just kind of a reminder because I think Most of you have heard this already, but a couple of you may not have. And remember that it is important for us as a town, as a town board, to make decisions that are well supported, well articulated, because within the last couple years, the Supreme Court has ruled that zoning boards may be liable, or towns may be liable to reimburse applicants for attorney's fees under certain circumstances. So if we make a decision that isn't well supported, that isn't substantially justified, we may end up having to foot the bill for the appeal, and we certainly want to avoid that at all costs. So the first step to defeating a claim like that is making sure at least the decision can be understood. Does anyone have any questions?
Yeah, hey, Amy, Rick Cherzak, I have one question. To make this easier on the person who is making the motion, okay, I was thinking in some way, I really like what we're doing when Jessica goes and reads what's in the file. Do you think it makes some sense that before, say, after we're done with all the testimony in any particular petition, to then have Jessica, okay, and in some way maybe we could have this automatically go into the motion to deal with the first 3 things or 4 things that we've got on this list. In other words, the following individuals spoke to the representatives of the applicant. You know, if these people are in the room and say John or Bob or anybody is making a motion, they see him there. They say, well, the following individual spoke as representative of the applicant. He sees sees Harry Smith and Joe Shridlow, but it's not so easy when we're on this computer this way. And I'm just wondering if we could, if in some way what we can do is say, all right, before we make a motion, Jessica, will you just list out all the people who have spoke in favor? I'm not saying she should give any type of summary, but just who they are. All the people who spoke in support, all the people who spoke in opposition, okay? And then that's kind of filled in this template, okay? What do you think about that?
I think that's fine. I think that's a good idea.
I'm just wondering how we do it now that I said all that.
So what I
Jessica?
can do, Amy, is if you can send this document to me also in a workable form, as people are speaking, I'm just going to type in, the following representatives. So I would say, John Kenyon and John Smith, whatever. And then I can also do the materials because I'm already doing that. And then, so then the board member would start with the finding of facts.
Yep. Good. I like that.
Okay, all right, good. So that helps, good.
Is it helpful to the board? There was a little bit of confusion, I think, last meeting on one of the applications where I have bolded the is or is not. Is it helpful to the board if I create separate templates for approval and denial so that you know exactly what to say? Or is that too?
I think
That was me. I think just color coding would be great.
Okay, all right, then maybe I'll do that. Maybe I'll do a green for a yes and a red for a no.
Okay,
Okay,
all right, and go ahead, yeah, and just one comment. I really think we should make an incredible effort to make this standard procedure every time to go through and because, as Amy said, this is what's gonna make it so we're not overturned. Though if we're overturned, we're overturned, so be it. But at least we're doing our part here. Okay, Amy, go ahead.
I have a question.
Yeah, go ahead,
Yes.
Bill.
With these motions, what's my position in making a motion? Is an alternate able to make a motion but not vote on it?
you are not able, you were able to participate in the discussion, but not the voting unless a regular member is absent. So the purpose of an alternate member is to participate. And then in the event that next, the application is continued until a further meeting and one of the regular members can't make it, well, you can step in because you were there and participating ideally by asking questions and listening. So, but if it goes to a vote and we have 5 regular members, then at that point, you just, you're just listening at that point. Yeah, we
Okay, but-
need a voting member to make a motion.
Okay, got it.
Amy,
Okay.
I think what I can do differently also, like how I was kind of shown how to, like when the motions come time to actually be recorded, you know, I was told you basically take what the stenographer sends and you dump it into a paragraph and do all of that. I can set up the motions a little bit differently. So
Mhm.
it'll basically be like findings of fact. I'll put your verbiage in there and then type in, you know, whatever it is that the member makes in the motion. So maybe it's a little bit clearer and not such this huge long paragraph like it has been.
Yeah, yeah, and I'll say there's a whole variation among the different cities and towns on how these motions are made, and many do it just like we do, which is more or less verbatim from the transcript, and it works 95% of the time, but then 5% of the time you can get into trouble if you're not careful with the because, and you know, is it and we've seen that before. Sometimes the solicitors write every single decision, and in most cases it's kind of in between, right? So I'm happy to start reviewing decisions, and let's try to use the template to make it easy for Jess, because the goal is we want to make it easy. If Jess is going to do that, put the decision in this template form to make it easy for her.
A quick question, Amy. Is the because pretty much standardized for all of these points, across dimensional use?
No, the because is what's going to be unique to each application. So, you know, and we can think of examples, right? You know, an undersized lot, a house that's already within the setbacks, wants to construct an addition, needs front and side setback relief. Why can't you build it elsewhere on the lot? We've got a septic system, you know, we've got a stone wall, we've got a shed, we've got a porch. What the because is the part that I can't fill in the template. The because is going to be the unique facts of each application.
Amy, I've got a comment.
Mhm.
So, as you know, we get many applicants that represent themselves, a homeowner and so forth. If they don't touch on one of these points, should the board members ask them, like, why the least relief necessary is there, or?
You know, that's a tough one to answer. Here's what I don't like to see, and I've seen other boards do it with self-represented applicants. You know, they'll try to tease it out. And Rick, at the beginning, you know, you as chair, you indicate what the standards are. You indicate, you know, we need evidence on all this. So they're on notice, but certainly you can't absorb that in the, you know, 2 minutes you're hearing it. If that's the first time you're hearing it, right? If that's the first time you're looking at the zoning ordinance, they're not going to come prepared with answers to all the questions like the attorneys will come prepared. I don't like to see boards put unrepresented applicants on the spot. You know, tell me, well, if it's 3 feet, why couldn't it be 2 feet, or why? But I would suggest asking questions that kind of draw it out. You know, have you considered alternatives, right? You can ask the questions, but I want to be careful that we don't, if someone can't come up with an answer themselves, you can certainly come up with an answer based on your review of the site plan, your knowledge of the area. So if someone doesn't exactly say the magic words themselves, just be mindful that you can kind of fill in those, fill in what you need to for the findings.
I know, I'll tell you, Wayne, on a number of occasions over the last 4 or 5 years, I've remembered people asking specific questions because we're trying to pull from them, okay, the right answer, you
Yeah.
know, and
Exactly.
not the wrong answer, okay? Because if, you know, and so I guess there's some finesse to that, you know,
Yeah. No, you've done a good job trying to do that.
you know, so.
Right. It is a balance between making the board's job easy and being friendly to applicants who come from all walks of life and with varying levels of sophistication. You know, some towns have these questions right on the application, you know, so before you even walk in the door or, you know, walk in the virtual door, you have to, it forces you to think about. And, you know, that's one option. I think the way that this board operates is good. And, you know, if you really have questions about, well, why can't it be, you know, why is the plan, why are you presenting the plan you're presenting, you know, versus a different alternative? That's a critical question to ask.
Should we put those questions on the application, Amy, or not necessarily?
You know,
Don't,
what about publishing the templates? I mean, I don't, is this this is not secret. I mean,
it is certainly not secret. The, don't the instructions include a copy of the standards, Jess?
I don't think they do. I know when people come in at the counter, I make them copies of the standards,
Mhm.
but I could certainly add that page, you know, to the instructions, you know, the standards of relief for a variance or a special use permit.
Yep, yeah, that might be a good idea. Just, and, you know, we can put a heading of, you know, your application will be considered according to the following standards, you know, as applicable.
Yeah, I'll do that tomorrow.
Okay, Amy, what else?
The other thing I want to note is, you know, sometimes I hear board members say tied to the plans. And, you know, it's a good thing to say on the record if they're, especially if, you know, you have a case where the plans don't exactly match what they're actually seeking. You know, they say, well, we're no longer going to build the deck because it wasn't advertised. And, you know, you say tied to the plans. In my view, though, whether or not those words are articulated, that goes without saying. The application and the approval is always tied to the plans submitted.
Okay, all right. Okay, what else, Amy? Are we, so we've got, you're not going to go over each one, you're just going to do the dimensional variance one and,
You know, let me just mention what hang on a sec. How do I?
I mean, obviously, we haven't had a use variance in about 2 years. I think the last one was Verizon with the cell tower.
I'll pull that one up.
But
Can
we
you
do have
see now that
special
it
use
says,
permits.
okay, can you see now that this one says use variance?
Yes.
Okay, so the real thing about the use variance is the land or structure cannot yield any beneficial relief unless the beneficial use unless the relief is granted. That means it can't be used for anything else. A good example that I can think of that I'm still wondering when we're going to see is the gas station. What was it called? Smithco, right? It's now Smithco on
Yep.
Route 1. Former gas station, tanks have been removed. It's in a residential zoning district. Clearly, it's not suited for residential use. You've got, you know, environmental issues. It's right on the road. That's a prime candidate in my mind for a use variance. If it's required to conform to the provisions of the ordinance, meaning only a residential zoning district, you're essentially depriving them of any beneficial use of the property. And that's a very high bar, and it's intended to be a high bar. Just a reminder that our ordinance still has that no reasonable alternative language in the dimensional variance section, but you all know that's been superseded by statute, right? The last criteria for a dimensional variance is simply that it would be more than a mere inconvenience if the relief were denied. Not that there is no reasonable alternative. No reasonable alternative is really like the standard for a use variance. So that comes up every so often when someone brings it up, and I always try to remind the board, and one of these days we'll get around to removing that language from the book. And let me bring up the special use permit one. The special use permit, I'll just note there are specific standards. I'm sorry, not specific, general standards for a special use permit in 907. And here they are in number 3 there, Roman numeral 1 through, 8. Ingress and egress, parking and loading, trash storage, utilities, screening, buffering, signs, yards and open space, general compatibility. But sometimes the zoning ordinance contains specific special use permit standards. And in some cases, those standards need to be satisfied in addition to the general special use permit standards. And in some cases, the specific standards are all that need to be satisfied. So as questions come up, let me know, because I can advise you on what those are.
Okay. All right. So basically, we've gone through these. We know that we're going to try to be. This is a standard. We're going to try, when we make a motion, to go right by the template, to go through, fill in the blanks. Okay. Hopefully, we'll after we've done it a few times, we'll get Jess involved with filling in these, this record keeping stuff and who's speaking and all that stuff. So you don't have to worry about that when you're making your motion. Okay. And again, as Amy said, the because is the biggie here. Okay. Okay. Hey, Amy, a couple of other questions I have for you. Can you just tell us where the hell we are with, I was always told that with regard to that whole septic system thing, that the state was going to do something so we don't have to do this anymore. When is this going to happen?
Good question, and I wish I had a better answer for you. There were draft regulations released, boy, I want to say somewhere around August to October. They have not yet been finalized. And this was a joint project between DEM and CRMC. So for now, our ordinance still stands. And they are, I want to say, 4 years overdue in promulgating regulations now, because I believe that legislation was passed in 15, and then they, the original deadline was a year, it was extended, and then they gave up extending it. I mean, I don't know why the regulatory process is taking so long. And of course, with everything that's going on now, that doesn't help. I certainly will let you know as soon as those regs are, officially effective. The law was, when the law was passed, the town couldn't adopt anything new restricting wetlands or setbacks, buffer areas, but our existing ordinances would stay in force until the new regs were promulgated. So the answer is we're still waiting.
We're still, with the advent of these new systems, I mean, we're going to get more and more of these because it's now lots are buildable that weren't before. Hey, Wayne, can I ask you one question? Okay.
Well,
When someone comes to you and wants to build a house, if they have a DEM permit, I mean, if they have a DEM permit for the septic system,
yeah,
other than our ordinance, something like this, that's it, right? They can put in a system. Or do you?
that's required before we issue a building permit.
Okay. All right. Okay. Okay. All right. Anyone have any other questions?
Just one quick one. Remind me, are these things that you went over going to be sent as .doc or something?
Yes.
Okay, thank you.
Yeah, my apologies for not sending them before the meeting.
Okay.
Okay, Jessica, what else do we have to talk about?
I am thinking that in June, we may need to have 2 meetings because we've got, I think we have 7 new petitions, plus we have the Brood Awakenings, and now the Walsh petition is carrying over. And I think between the Walsh and the Brood Awakenings, that could take up a whole night just those two.
I
Um,
agree.
So I think we need to look at also having a meeting on 6/24.
6/24. Okay.
And Jess, would you recommend just those two petitions that we know are contested, schedule those two on that night?
That's what I would think.
I agree.
Okay, now, next week, we only have on what? Just those two that are going over for Kenyon, and then what?
And then one new one, which I believe is an OWTS, isn't it, Wayne? The Lind Pole 4 Red Feather. I
Uh,
believe it's an OWTS.
I believe so. Let me just,
Okay, but Kenyon has one that have been renewed already 2 or 3 times, right?
Yeah, there's two from Mercier. One was a
Mhm.
variance, one was a special use, and it's the third extension request. And then
Amy,
as a
Amy,
note-
just give
sorry.
us some guidance on that. What type of scrutiny are we supposed to give to that with a third request?
Hang on a sec. Let me bring up that provision of the ordinance. I don't know that there's a different standard. It does have to get a public hearing, unlike the first one and maybe the second. Hang on one sec.
yeah, I think they need some type of written, for the third one, it has to be written reason as to why they're seeking.
So as you know, applications are valid for a year. The first extension is, for cause. Upon written request and for cause shown, can be renewed for a second 1-year period. A further extension for cause, again, requires written request. It can be renewed provided that the applicant can demonstrate due diligence in proceeding and substantial financial commitment in promoting the subject of the variance or special use permit since the date of the filing of the resolution. Notice shall be given and a hearing shall be held. So, and that's section 910B. So 910A is the first extension just for cause shown, no hearing required. Further extensions require due diligence and substantial financial commitment.
Okay.
John also has in June, I don't know if you guys remember, but there was two separate parties who had lots right next to each other down there. The other one was Drew and Heffernan. It's the same exact thing as Mercier. He has those on the agenda for June. So we'll have Mercier's next week, and then June, you'll hear the same thing for the other party.
So
Okay.
if we do that other meeting in June, Amy, will we need to get approval from Brood Awakenings and John to push those off to the following week? Or do we hear them in the same order that they were received?
It is the chair's prerogative, and staff's also recommendation. You know, we want to be careful to avoid playing favorites as far as who gets heard first. But everyone knows contested petitions take more time, and it isn't fair, quite frankly, to the other applicants, as, you know, we expect that, you know, they'll be uncontested generally if we don't get opposition letters before the meeting. I think that's reasonable, but I would, you know, out of courtesy, ask if they and their teams are available that night.
So we're still going to, so for the June agenda, you know, say I've spoken to everyone and they're all fine with that. The June agenda, I'm going to list them as part of the June 17th agenda. And then on the 17th, we are going to continue them to the 24th.
Yeah, and if we know in advance if everyone's on board, the applicant, we don't necessarily need the objectors on board for the 24th, but if the applicant is okay with being pushed to the 24th, you can put on the agenda for the 17th, you know, to be
heard.
continued. Exactly.
Okay. And I had one more question about the Brood Awakenings one. Should we advertise that one again? I know we already advertised it, but where it's so contested, would it hurt to put it back in the paper again when I place the ad tomorrow for all of the other stuff?
You know, it certainly doesn't hurt. The only question is typically we pass the advertising cost on to the applicant. So, you know,
All right. I don't need to know. So, okay.
yeah.
Okay. All right. Anything else, Jess or anybody?
I have a question for
Yeah.
Amy. So Amy, my question involves in a fictional petition where the petitioner presents an expert to give their opinion, say a traffic engineer, and the objectors, and maybe there's a few of them, and they live within the radius, they don't have a traffic engineer, but they present compelling testimony because they live there. Do we have to accept that expert opinion? Does it have to be considered uncontroverted, and we have to accept their findings and conclusions, or can we side with the lay people based on their testimony?
Yeah, good question, John. So truly uncontroverted, accepted expert evidence may not be rejected. That means that nobody, meaning objectors or anyone in the board, has anything to say about it. So if a traffic expert says X and nobody, then the board can't disregard the expert's findings. Where you have people in the neighborhood who are who have pointed out flaws with the study, or who have made their own observations, the board members have to be careful, because that's a subject, particularly with traffic, where you can really get burned. I've seen people come up and they'll present videos, well, I did my own traffic study. I was out here for one day, and it's like, you think it's easy to be a traffic expert. You think it's just a matter of going out and counting cars, but there's more to it than that. But you certainly can rely on your own knowledge of the area. And if there are, again, a traffic study of the area, if they do it on a day or a season that seems inappropriate, there may be reasons to doubt that. Certainly, if it's a very experienced traffic expert who, you've accepted their evidence before, you've accepted their expertise. And keep in mind, a traffic expert is just an expert on traffic, right? It doesn't mean there won't be an impact to the neighborhood. It just means, here's what the traffic impact is going to be. Is it going to be substantial? Is it going to be, moderate? But it's my opinion that the roads can handle it. So the answer is, you are not barred from rejecting expert testimony where there's a good basis to do so. You just have to keep in mind that is an area where you can get burned, because the idea of an expert witness is it's usually something ordinary people are not qualified to opine on. And as much as we all think we're experts in traffic because we all drive around every day, the courts have said that specifically traffic is an area where lay testimony is generally not competent. However, again, there's a difference between uncontroverted and controverted by lay witnesses. I know it's not a great answer in isolation, and I prefer to give advice, in the context of an actual application on that.
Right. I get it. I guess my follow-up would be, I always consider the traffic experts to be like the ugly stepchild of the whole expert engineers that get presented in these petitions. But they're not engineers, right? What makes them an expert? Can you become a traffic expert without a high school degree?
Like car,
What was that, Bill?
like car spotting.
Yeah, sometimes they are engineers, and that goes to, and we typically don't scrutinize the resumes, but, if they hand in a resume, ask about their experience, ask about how many years they've been holding themselves out as a traffic expert. So I don't know that, Rhode Island has a specific category. I don't think it's a licensed, an engineer certainly is licensed, but
Right.
traffic experts, some of them, some of them are good and some of them aren't so good. So
Agreed.
it depends, but that's a rule you certainly can exercise, is this really an expert witness?
Right.
Amy?
I'm only saying that because I anticipate it with the Brood Awakening petition.
Mm-hmm.
Amy, just a question of clarification. The board has to accept that person as an expert witness, is that correct?
Not necessarily. I mean, routinely, I don't think we routinely we usually don't even go through the procedure. Sometimes some attorneys ask, I'd ask that this expert that this witness be considered as an expert witness in the field. And I think the last time we had arguments about that was in the context of one of the Oyster Bar appeals.
Well,
Usually yeah.
I guess my question then would be, I mean, if we don't accept him as an expert witness, then we can accept the testimony of everybody that's testifying about that particular aspect of whatever he's testifying to, no?
Yeah, I think you'd have to have a very good reason for rejecting someone's purported expertise. And I think that would have to be based on a thorough review of the resume, a thorough questioning on their experience and training. We typically don't do that, and I think for good reason, right? If this were a court, you'd have a whole day set aside to, who's an expert, who's not, what are they competent to testify on, what books have they read, show me your report. We follow relaxed rules of evidence. And again, I think we do have to have a good reason if we were to reject someone as an expert. I haven't seen it done. I'd certainly be uncomfortable in the field of traffic study. If someone, I don't even want to go the hypothetical route, but I would be very wary of rejecting someone's expertise. I would rather just, if someone has reservations, whether they're on the prevailing side of the motion or not, state those reservations for the record. And if you're rejecting their conclusion versus rejecting, their qualifications or their expertise entirely, you can certainly discuss that.
Yeah, Tom, if you look to our procedures, if a attorney, and Kenyon does this quite a bit, he will ask if someone be qualified as an expert.
Yeah.
I ask you people, if any of you guys have a problem with this person as an expert witness, because that's what the procedures say I'm supposed to do, okay? So that if there is a question, we should discuss it and we should say, well, why the hell are you an expert at this, okay? It seems to me that the majority of these people that come before us have been before 72 boards on this, and I mean, and you know how it is about experts. You get an expert to say a wall is black, and another expert to say the wall is white. Just like a lawyer, Amy and John, same way, But so I guess we have to use our own knowledge and whatever and decide,
Mm-hmm.
In any event. Okay, anything else? Okay.
Anybody have any idea when we're going to go back to seeing each other in live person?
I know, it's just kind of fun,
The Open Meetings Act executive order that allows the Zoom meetings was extended, right? It expired on May 15th and it was extended until June 15th. I fully expect that's going to continue. The 5-person gathering limit is still in effect until May 23rd. I think we've heard, and I don't have all the numbers and dates at my fingertips, but I think in the future phases of reopening, the limits are going to gradually be up to 10 and to 25. this is a discussion we're gonna have to have with the, you know, the manager and staff, and see what the council wants to do. But in my opinion, you know, until we can all be in the same room together, until we really don't have to worry about limits, it makes sense to continue doing all virtual meetings. Maybe we will at some point move to a hybrid where it's, you know, people can call in if they want or appear in person, but you know, there are no exceptions on the gathering limit, right? So, but we're starting to see, right, churches are going to reopen, you know, restaurants, businesses. So I don't have any inside info, but I think you can expect June, July, August. This is going to be the standard operating procedure. We'll have to see what happens beyond that.
Okay.
Okay,
Thank you.
anyone, anything else? Jessica, did you need anything from us? Well, I mean, I'm assuming everyone in this room is available next week? Yeah, okay. And you're gonna find out if Cagnetta is available, I would assume, Jess. So,
Yes.
okay, all right. Does someone want to, we don't need to make a motion or anything on this, do we? I just
Are we going
quickly,
to deal with the minutes?
oh, yeah,
Oh,
you want to
that's
deal with
right.
minutes?
Then I
Okay, who
have a
wants-
question after that.
Okay, someone want to make a motion to approve the minutes of the last meeting?
I'll make the motion to approve the April 29th, 2020 meeting minutes.
Okay, someone second that?
Second.
Okay, all in favor, say aye.
Aye.
Aye,
All right.
Aye.
good. All opposed? I hear no one opposed, so passes. Okay, what is your question, Wayne?
Amy, is it possible for you to give us an update on the Dion appeal? How that process will work in the court? And what is the applicant or the person that's filing the appeal? What do they have to prove to basically get this overturned?
Yeah, I was contacted by an attorney who the appellants have retained. And the question was whether the town had enacted an ordinance allowing remote meetings. And I said, well, no, you know, and as far as I know, no town has done that. You know, all the towns that have held remote meetings, there was no council action taken. It was just, here's the executive order and we're proceeding under that authority. So, you know, they retained an attorney. He knows, he's aware the decision is recorded. They have 20 days to file in the Superior Court. You know, everything's changed now with courts are closed, but e-filing is still available, and statute of limitations like the 20-day appeal deadline in the Zoning Enabling Act, those remain in full force. So, you know, they have to file a complaint. They have to provide notice to abutters, and abutters may intervene. Obviously, the applicant will need to retain counsel. And it goes to a review of the evidence. Now, in some cases, and we've seen this before, and in fact, it happens sometimes in cases where one party didn't have, or both parties didn't have representation before the board. Because often when you have parties with representation, sometimes differences can be worked out. And sometimes people have a price, quite frankly. And I'm not usually involved in that side of it, but sometimes negotiations can make a case go away. So, but if they're insistent, they certainly, you know, the case is briefed, and then it's a review of the evidence. It's the judge deciding for himself or herself after reviewing the evidence, which is submitted to the court, after reviewing the decision, the transcript, and the briefs of the parties. Does substantial evidence exist to support the board's decision? You know, to the extent that there are going to be questions about due process and procedure on Zoom, I'm confident that we can, that we will prevail on questions like that, because at the end of the day, I think we went above and beyond to ensure opportunity to participate. And, you know, not everyone can participate in in-person meetings, right? You gotta work. If you have to work at 7 o'clock, you can't come down to town hall. You know, if you don't have money for a bus pass, or if you don't have a car that works, you can't come down. When an objection letter is read into the record, or at least noted for the record, when the concerns raised by objectors are discussed, and when the board members discuss at the meeting and indicate in the decision why they voted the way they did, you know, and sometimes the decision will be flipped, sometimes not. But at least I think we can take comfort in knowing the decisions that this board makes routinely are well supported by the evidence. And everyone, I think we afford a fair hearing to everyone.
Okay, thank you, Amy.
Okay, anything else?
Rick,
All right,
I may
well,
just want to ask, because we do have someone in attendance, if they have anything that they wish to.
just do you have to tell them how to do it? I don't-
Sure. So if anyone in attendance wishes to speak, you're going to need to raise your hand. If you're calling in on a phone, you'd need the *9 to raise your hand, and then *6 would mute and unmute. So if there's anything you need to, you want to speak about, please raise your hand now.
Ask them if they want to be a member.
All right. Nothing's happening. So
Nothing. Okay,
Sometimes people call in just to see what the show is. You know, I called into the Narragansett Council meeting this week. I wanted to see the fire leader.
all right, well, I guess that's it. Jess, I guess you could end us.
all right. Thank you
Okay.
all.
All right.
Thanks. See you next week.
See you next week.
Thanks.
Good
Yeah.
night.
Bye-bye.
Bye-bye.
Thanks, Amy.
You're welcome.